Are there any other burning questions? Yes, sure, Senator Hill.
Yes, currently minors under the age of 18 are unable to apply for citizenship while they are being charged under the Youth Criminal Justice Act. However, they can apply after they have received a conviction. Is that correct?
Sorry, that they can apply for, I missed the beginning of your questions. Apologies.
Currently, minors under the age of 18 are unable to apply for citizenship while they are being charged under the Youth Criminal Justice Act. And however, they can apply after they have received a conviction. Is that correct?
I'm afraid I'm not in a position to comment on whether the Immigration Refugee Protection Act includes that provision. To the extent that I'm aware of the concern about the Immigration Refugee Protection Act and C-45, it has been more with respect to what would happen if there was a conviction. Would it have a negative impact on a permanent resident's ability, for example, under IRPA, if it constitutes serious criminality for the IRPA effect? But that's not, I think, what you're asking.
Immigration officials coming in for that?
So it's a question that I'd be happy to see if we could get a response from colleagues at Citizenship and Immigration, but I'm not in a position to answer.
Okay, that would be appreciated. Thanks.
Thank you. And Senator Seaman, you had a quick question?
If I could just go back to recommendation number 1, because I just want to be really clear about what we heard. And I know Senator Pennyclair asked a question. We had some discussion about it, but I'd just like to be really clear. So, the provinces have been given jurisdictional rights over certain aspects of this legislation, such as age, retailing of the product. So why shouldn't the provinces and territories have the right to decide what's best for their communities as far as growing plants at home is concerned? Quebec and Manitoba have already decided they want to prohibit it. Why shouldn't they also have that jurisdictional right?
This question, Senator, has both a policy and a legal dimension to it. From a policy perspective, we can go back to the report of the task force where it examined the issue of home cultivation. It also studied what had gone on in those states that have legalized cannabis and have authorized cultivation at home. My understanding is that most states that have legalized adult consumption of cannabis have also allowed for home cultivation. The task force examined this, they visited some of these states, and from a policy perspective, they recommended to the government that home cultivation be allowed, but they set it at 4 as opposed to 6 or 12 or 8 plants, which exists in some of the U.S. jurisdictions. The thought being that this would help reduce illicit activity. It would give adults access to a source of lawful cannabis. And the government, in considering the task force report, took this into account. And this is the reasoning behind this allowance for the cultivation of up to 4 plants. What, from a legal perspective, has been set out is that the criminal law doesn't apply to the cultivation of 4 or less plants. So by not applying the criminal law to that aspect, it leaves room for the provinces to come in and set in additional restrictions. However, in doing so, they have to keep in mind the purposes of the federal legislation. And one of the, perhaps 2 main purposes of the federal legislation is to provide for legal access by adults to a lawful supply and through the production of cannabis, and also to help eliminate the illicit market. And so not encourage home cultivation in an illegal fashion. And these are the purposes that provinces and territories need to keep in mind when they develop their legislation. In doing so, they can, as Quebec and Manitoba have done, prohibit home cultivation. And the federal government has been clear in that it is not going to challenge provincial laws in this regard. However, individuals may feel it's too restrictive and then may take issue with their own provincial legislation. And it's in that context that a court would look at the purposes of the federal legislation and the purposes of the provincial legislation and make a determination accordingly.
So if I might just ask one more clarification on this. So, the Quebec minister, Jean-Marc Fournier, appeared before the legal committee, and he recognized, there were complications here. And he did say, and I'm going to quote him, "You could clarify this in order to prevent legal challenges and show that you prefer federal and provincial governments to work together rather than against each other." So the federal government has that opportunity to clarify this and ensure this in the current legislation.
So officials at the federal level, and I also believe ministers of justice and attorney generals across the country, do meet and do have conversations and exchanges on cannabis. Again, I would point to the testimony of the Minister of Justice before the Standing Committee on Legal and Constitutional Affairs. The interest here is in establishing a national program whereby the rules set out by the federal government apply across the country. And so ultimately, I think that is the federal government's objective, is to allow for home cultivation of up to 4 plants to provide this national consistency.
Okay, I'm going to clarify one little part of that. You said that if a province decides, such as Quebec and Manitoba, to go to 0, as opposed to, they can go 4, 3, 2, 1, but they can't go to 0 under the law. But you said that the federal government has made it clear that they would not oppose that. But if a citizen brings an action before the courts, what will the federal government do then? Will it intervene, or will it stand aside?
So if the challenge by an individual to a provincial statute, for example, also involves the federal statute, then the federal government would look at defending its legislation.
Okay, all right. I think we need to pack this panel up because we're running way over time, but it was very important to get a lot of these matters on the table. So thank you very much. I think the people that are opposite me are by and large staying. Maybe only 1 or 2 changes, but we are adding for the next session Department of Indigenous Services Canada and the Department of Crown Indigenous Relations and Northern Affairs Canada. Are those people in the room? They're all in the room? Well, if the clerk can figure out how the seating arrangement should be, then we'll get on with this. I'm not going to suspend. I'm just going to watch a few chairs change.
Lisa is going to address Senator O's question with the immigration officials now, so they're prepared to discuss.
Okay. Could come to order, please. The second report we will now deal with is the report of the Standing Senate Committee on Aboriginal Peoples. We again have Health Canada, Department of Justice officials, now adding to it Department of Indigenous Services Canada, Department of Crown Indigenous Relations, and Northern Affairs Canada. First time I've seen those new titles. And unless any of you have any opening comments, I would then draw your attention to the report. Page 16 are the recommended amendments. There are also policy recommendations which, if dealt with or however they're dealt with by this committee, would be in regards to observations. But the recommended amendments to the bill on page 16 start with the delay, number one, the delay in the coming into force for the reasons outlined A, B, C, D, and E. And then the second one is prescribed that the Minister of Health reserve at least 20% of all cannabis production licenses, etc. So, I'd like your comments on page 16 on the recommendations and the rationale of the government's position vis-a-vis this recommendation. So, who wants to start? Mr. Costin again?
Sure, I can start. And Mr. Chair, would you like to proceed in a similar fashion as we did previously and kind of go
Yes.
one A, B, C, and,
Sure.
and through it the list
Sure.
entirely?
Sure.
Well, perhaps I'll say a few things with respect to one, absent any of the sub-letters, just to begin, and then between colleagues from other departments, we can certainly offer some reflections on the remaining recommendations. So in the earlier session, I was asked a question about delaying of implementation. Again, in the wanting to be respectful of everyone's time, I don't know that I'll want to repeat everything that I said earlier. I think I would, by way of comment here, perhaps say that you no doubt, and APA certainly heard and discussed at length questions of engagement and the degree engagement and interest that exists amongst First Nations, Inuit, and Métis communities. And that interest, no doubt, that you heard and they heard is quite varied. Everything from questions about and concerns around the health impacts and the community impacts that these decisions will have, impacts on law enforcement and community safety, and economic interests. I think you also, and APA also reflects this, is the reality in many communities today is not that different than it is in the rest of the country, insofar as you have a free and easy access to cannabis. You have cannabis sold openly in some communities, a proliferation of stores. Again, not a lot different than what you would see in Toronto or Vancouver or Ottawa or most major cities these days. The product that's sold is, as has been discussed at length, free from any government oversight or any oversight at all, and there are a number of harms associated with that. And so really the reflection to questions of delay is not to set aside that there are not concerns and very legitimate questions around how to roll out implementation in a way that will be the least disruptive and the most beneficial for communities, but it's really an acknowledgement that a delay would in effect preserve the status quo, and the sense of proliferation and early movement and anticipation of something would likely continue, and a certain sense of chaos, if I may, would continue. And so the government's position really has been to invest a lot of time and effort in going to communities. We're up to, since we last spoke to APA and spoke to you, we are up to 50 or 60 different community visits. We do 3 or 4 every week where we're in the communities talking to chief and council, in the case of First Nations communities, community members themselves, organizations, with very much a view of of hearing the concerns, working together to develop strategies that will address the concerns that they have, and also equally look at strategies to facilitating their interest in participating in the new regulated industry, and so on and so forth. So I think that's what I would offer by way of response to simply the very first recommendation with respect to delaying. I don't know, Sheila or Valerie, if you want to add anything. No.
No? Okay. So you're not going to go down through the ABCD. That's just the general.
Certainly can. I don't know if you
Well, we
want to
can leave it open till questions, unless you've got something to respond to in these cases.
Well, okay. In that case, I would actually like to point to a few of them, and so I think on questions of tax matters, as you likely know, that they're not currently in C45. The questions of excise tax are dealt with entirely through the Budget Implementation Act. So I don't know that we have any comments to offer on A. Sheila, you want to say something?
So, I mean, certainly the taxation issue is the purview of the Minister of Finance. What I will say is that through the new fiscal relationship work that we are undertaking with Finance Canada, with self-governing First Nations, and with the AFN, there is a line of sight through that process to look at taxation, changing taxation for First Nations, self-governing First Nations and Indigenous people, as well as resource revenue sharing and those types of mechanisms. So the discussions in and around that are going to go through that venue, and the government has been very clear about that, and AFN has released a paper in December 2017 in and around the status of new fiscal relationships. So I can offer that as an addition.
Thank you. I neglected to welcome you, Sheila Murphy, Assistant Deputy Minister, Lands and Economic Development in the Department of Crown Indigenous Relations and Northern Affairs. Also, Valerie Gideon, Senior Assistant Deputy Minister, First Nations and Inuit Health Branch, and Stefan Matiation, I hope that's correct, Director and General Counsel, Aboriginal Law Center, who's with the Department of Justice, who have joined us, and the other folks at the table were here the last round. Okay, any comment on B?
Just very, very quickly, this is something that we're utterly seized with. In fact, the last federal budget included $62.5 million to support community-based education efforts, including in Indigenous communities, and so that is really, I think, a very tangible action that speaks to the need and the government's willingness to work with communities to develop culturally specific, linguistically appropriate education materials. We are currently translating a number of documents that have already been developed into a variety of different Indigenous languages. And so I think on that one, it's a very, very important and vital recommendation, but it reflects a kind of a road that we're on presently, and there's quite a bit of work underway. Do you have anything else to add, Valerie?
The Thunderbird Partnership Foundation, which is headed by Carol Hopkins, who's recently received the Order of Canada, very well recognized Indigenous expert in mental health and addictions, is leading regional dialogue sessions across the country to inform the development of specific public education tools. She has strong support from First Nations and other Indigenous leaders to undertake this work. It will be presented to the Assembly of First Nations Task Force that we are on, specifically on cannabis legalization, that we are also supporting. They've recently started meeting. They've hired someone to specifically coordinate the task force. They're planning a national summit, which will also be an opportunity to get some specific input from communities with respect to education materials. Our minister, Minister Philpott, is also very committed to ensuring that with Budget 2018 resources specific to addictions treatment, which I'll speak to with respect to one other element in your recommendations, she has been very strong in ensuring that we have a public education campaign also as part of addressing the complex needs of high-risk communities with respect to addictions, which of course would include cannabis.
Yeah, one thing here, the preamble up here, number 1, says the Government of Canada negotiate and agree on the following deliverables. So you're talking about some of the things you're doing. Are you doing it in the context of a negotiation?
In terms of the public education materials?
including all A, B, C, D, E. The preamble, I'm talking about page 16 of the committee's report. It talks about the delay for up to 1 year, but it says the purpose of the delay is for to allow time for First Nations, Inuit, and Métis communities and the Government of Canada to negotiate and agree on the following deliverables. Is that in process?
Well, the work that we started with Thunderbird Partnership Foundation last year and with the Assembly of First Nations last year was to prepare for the aspect of legalization coming into force this year. I don't know, Eric, if you can comment specifically
But that's some
on that,
form
but
of
they have been-
consultation, is it, as opposed to negotiate and agree? I'm trying to understand how much of this you're actually doing.
We're responding to what they've brought forward as needs in order to support
okay.
the education of their membership.
Okay.
Projects that Valerie is describing and that I mentioned very generally, the pot of money that was allocated through budget, it really is a negotiation. It really is a conversation with communities where they present their interests and we do our best to accommodate them with the monies that have been provided.
Okay. And what about C? Any comments on C?
So, so with respect to C, I do note that there is also a policy recommendation on that one, so I suspect that we'll have more discussion there as well. But this is getting at the issue of Indigenous jurisdiction. And I guess the starting point and kind of just a few comments on this is that the Cannabis Act itself is a law of general application. It applies across Canada to all Canadians, including, or it would apply to all Canadians, including Indigenous peoples. And the regime itself doesn't include provisions that would recognize or empower Indigenous lawmaking in this area. But like the Criminal Code and Drugs and Substances Act and Controlled Substances Act, it is legislation that will operate in a framework of other laws and powers. You know, some Indigenous communities in Canada do have self-government powers under their legislation, and there are rules in those agreements regarding the relationship between Indigenous lawmaking and you know, things like criminal legislation, Criminal Code Act, or the Criminal Code. And also under the Indian Act, there's certain, you know, bylaw making powers there as well, including regarding intoxicants, and some First Nations do use those bylaw making powers to deal with certain, you know, issues around intoxicants and health and wellness in their communities. So the regime doesn't address, you know, jurisdiction itself. But it will operate within kind of an existing framework of other types of authorities that Indigenous governments have.
Okay, item D is substantial funding. That's a policy question for the government, but what about the rest of this? What's being done on the rest of this?
Well, I can speak to that. So when we last had an opportunity to address the committee, we spoke about significant investments that had been made by the government with Budget 2016 in the area of mental health with respect to establishing mental wellness teams across the country, quadrupling the number of those teams. They are all hosted by Indigenous communities and mandated by leadership. They serve up to from 4 to 10 communities each. In provinces like Ontario and Saskatchewan, for instance, all communities have mandated that they will have access to a mental wellness team. We also establish a Hopeful Wellness line, which now has a chat function, which is similar to the Kids Helpline chat function. This is all governed and managed through an Indigenous organization. We also received funding in Budget 2017 of $204 million specific to mental health as well, to continue to ramp up access to services for communities. That also includes expanding the non-insured health benefits, mental health counseling to include access to traditional healers. And we've seen an over 100% increase in use of the mental health counseling benefit and non-insured over the last few years. So there's a significant improvements in access to the benefit. We are using also funding agreements with communities to deliver that benefit instead of only on an individual or family basis, and that's expanded access. And since we've had an opportunity to speak to this committee, it was prior to Budget 2018. In Budget 2018, we've also been able to access $248 million resources, extension of the Indian Residential School Health Support Program, which has been a very successful program to support families, individuals, and communities with healing resulting from the intergenerational impacts of residential schools, but also other impacts related to colonization. And we've been able to also access, as part of that, $200 million for addictions treatment, specifically over 5 years, with $40 million ongoing to expand access to treatment center capacity, on the land initiatives, a variety of different mechanisms to improve and modernize access to addictions treatment services for communities. We are continuing, as reported at our last committee session with you, we are continuing to support the feasibility assessment for the design of a treatment center in Nunavut, which, as we had referenced, would be cost-shared with the Land Claim Organization, the federal government, and the territorial government, so we're continuing to plan for that effort. There is a On the Land collaborative in the Northwest Territories, as an example. There are on the land and treatment services that are being offered also in the Yukon, so there is a lot of progress and ramp up in capacity and access with respect to mental health and addictions compared to where we were in 2015.
Okay, so you've commented on D and D together. So finally, there's recommendation 2, prescribed that the Minister of Health reserve at least 20% of all cannabis production licenses for producers on lands under the jurisdiction or ownership of Indigenous governments.
That one, Mr. Chair.
Yeah.
So I think there's an important detail that perhaps as officials or even personally I didn't do a good enough job setting out when we had an opportunity to present at the Aboriginal Peoples Committee. And that's the proposed licensing scheme, and that the proposal does not include any sense of a supply managed arrangement where the government would set a quota or a maximum number of licenses of any kind. It really is a program where the regulations will set out licensing criteria. Applicants will make applications for a license, and then they will receive a license, and the market eventually will sort out how many and what the market looks like. It's not an arrangement where the government has said we're only going to issue 100 licenses. In order to identify what 20% looks like, you would need to have some type of denominator. And so really the way the recommendation has been crafted and worded, it suggests that there's a denominator, and the reality is there is it's an infinite number of licenses, and so identifying 20% of an infinite number is not something that's possible. But insofar as we understand the interest, the sort of the prerogative behind the recommendation is to ensure a participation of Indigenous communities and companies in the regulated market. That's something that the government's taken on board quite a bit. And the two things that I would point to, we recently, in the context of the program for issuing licenses for medical cannabis production, we've created what we call a navigator service for Indigenous companies and Indigenous peoples specifically. So recognizing that the process of navigating the regulations can be a complex one, a difficult one. Many in the private sector rely on consultants, and these types of services, and they're quite costly. They are not always available in First Nations communities, and First Nation proponents may not have the means necessarily. And so what we've done as a regulator is to try and create a navigator service, a concierge service, if you will, that will help interested Indigenous entrepreneurs navigate the regulatory environment and successfully arrive at having a license. And that's really meant to foster a participation in the regulated market in the absence of having some type of hard quota that would reserve a certain portion of the market for Indigenous companies. This has been the practice that we've put forward currently, and we would move, we would continue to establish. And I don't know if Sheila, you want to say a little bit about some of the economic development support programs that your department provides that also supports small businesses, Indigenous-owned small businesses, including cannabis businesses.
Well, you might also describe, what is this navigator service you referred to? Is it?
So the Navigator service is it's employees that work in the Health Canada regulatory program, the licensing program, that exist solely to work with interested Indigenous companies who want to put in an application and work with them step by step through the entire licensing process, so that they can move expeditiously through that vetting process in order to meet the requirements that they need to meet without necessarily having to rely on outside consultants and these sorts of things. It's meant to create an easy pathway into the regulatory environment.
Okay, I want to get to the committee members. Is there anything else you want to quickly add there? Okay, committee members, start with Senator Seidman.
Thanks for giving us an overview. It was helpful to listen to. I would like to ask specifically about recommendation 1D and E, and it's also under policy recommendations 4 and 5, and that all relates to health, treatment, and addiction. So the Aboriginal Committee heard that there are no treatment centres in the North now, and that there's an enormous concern that this legislation is being rushed through before the necessary mental health and treatment support services will be ready. So you mentioned, you've added some budget, you've had meetings, you're in the process of designing and planning addiction center, but what mental health and treatment facilities will be available and in place in the North at the time of legalization?
So we will not be there at that point.
You won't be there at legalization?
No. So people are accessing by going and accessing treatment centers that are not in the territorial context.
Do you have concerns that there are vulnerable youth who are more susceptible to addiction in remote and northern communities, and they will be disproportionately impacted by this legislation?
Well, I can't comment with respect to whether or not they would be disproportionately impacted. What I can say is that youth at risk is a ongoing concern of the government, which is why they have made substantive investments over the last 3 federal budgets in order to support increases of accessibility to mental health services and treatment services. But the design and build and staffing and creation of a treatment center in a northern context is something that requires a lot of community engagement, a lot of participation. We also would have to ensure, as partners, that it will be sustainable with respect to the recruitment and retention of workers. And so it is a multi-year exercise.
So I guess I have to ask you, listening to that, what analysis was done by your department on the impact of this legislation on the mental health and well-being of Indigenous youth?
So we fund on an ongoing basis health survey research that is done by First Nations in order to assess trending with respect to youth in terms of their self-rated state of mental health and addiction support. In Budget 2018, for the first time, the government announced dedicated resources for a specific Inuit health survey that will also be funded on an ongoing basis, which will enable Inuit for the first time to self-direct and conduct research with respect to their population that will be comprehensive and based on their needs.
But then do you not understand why there's a certain degree of concern that this is all too fast for First Nations in the North with no facilities to deal with the impact that we can imagine this legislation will bring this summer? And there are no services. There are no frontline services on the ground operationalized now to deal with it.
There are frontline services. There's no residential treatment facility. It does not mean that there are not frontline services that are available through the territorial governments. We do fund and have been funding for quite an extensive period of time specific top-up supplemental funding to what territorial health systems receive, specific to supporting Inuit and First Nations in relation to mental wellness. We do that through 5 to 10-year funding agreements. In Nunavut, for instance, it's a tripartite MOU that directs those investments. There is some significant Inuit engagement with respect to where that funding is allocated. We funded in 2016 the implementation of the National Inuit Suicide Prevention Strategy, which was developed by Inuit, designed by Inuit. They are driving the implementation of that strategy. So there has been quite a bit of recognition about the importance of increasing frontline support.
But there's still no treatment centers on the ground to deal with.
There is not a residential treatment center on the
Thank
ground,
you.
but people can access treatment services.
Okay, thanks.
Thank you. Senator Petitclerc.
Thank you, Mr. Chairman. I would like to come back to an issue. It's a little destabilizing if we compare what we're hearing today, what's contained in the report, and what we've heard from the Aboriginal Affairs Committee with regard to consultations. It seems that what various people are saying is different. You seem to be saying that you're happy with the consultation. But if we read the report, and if we recall the testimony we heard, the Aboriginal Affairs Committee and individuals as well as organizations have said that there has been a lack of consultation. It was not adequate. It was not representative of different cultures, languages, and Aboriginal peoples. In fact, what I retain from what we've heard is that the consultation was linear, not necessarily superficial, but linear. That is, well-known organizations were consulted, but the hearings did not dig any deeper. MTI, Alakikuat, and other organizations, including the Inuit, said consultations were not good enough. The AFN said that they were not ready for this legislation. So I would really like to hear it told like it is. Are you satisfied or not with the consultations which were that were held? Thank you very much for the question. If you don't mind, I would prefer to respond in English.
Really excellent question. And you'll forgive me. Declaring whether the consultations are adequate, that's a very difficult question to answer. Really, what I can do is describe the consultations that have occurred. The determination about whether those consultations are adequate from the perspective of a variety of people is really, I think, a determination left to others to make. And I have been. I was at the AFN Special Chiefs Assembly a couple of weeks ago, right, and heard very much of the same commentary. So what I can do is simply describe what efforts we've made to have a dialogue, and again, I will try to be mercifully brief here. It has been a process, right? A process of discussion, and so when the task force began its work, there was participation at the variety of regional events. There was a kind of a separate Indigenous roundtable, but that then kind of has grown. There's been some ministerial engagement to the national organizations and to some regional organizations. And in my direct responsibilities over the program, we've been in, as I said, sort of 50, 60, 70 communities in the north, east to west. we recognize, and so in those communities, to sort of create a mental image, sometimes it's a meeting with 5 or 6 decision makers, and sometimes it's the entire community. We have 700 communities spread out across the country, a number of regional, local, national organizations. We understand the interest. We've made ourselves as available as possible. We've created lines of communication, established governance structures. These have all kind of emerged over time. I think I mentioned before, we have a dedicated outreach unit, staff who do nothing other than Indigenous outreach. Whether all of those activities at the beginning at the task force, the ministerial outreach, the officials outreach, whether those are seen as adequate enough is, again, I'll leave that judgment to others. In sharing that information, it's just to acknowledge that the interest and the desire to have that conversation, to hear the concerns, to work through them exists. And we will continue to do this, and we will continue to do our best to meet all of those interests, to have those conversations.
Okay, thank you very much. Senator Gold.
Thank you, Chair, and thank you for being here. I just want to clarify my understanding just on the consultation point, and then I'd like to speak a little bit about the specific amendments. Do I understand correctly that the current state of the law, of constitutional law in Canada, is that there is actually no duty to consult on the legislative process? There are consultations, there are all kinds of things, but that there's no actually legal duty on the government, under the current state of the law, to consult on the legislative process. Am I correct in that?
Yeah, I mean, that is correct. Based on the guidance that we have so far from the courts, you might be aware that there is a case before the Supreme Court now that will be important on that issue. But, you know, as you mentioned, I mean, engagement and consultation in the development of legislation is certainly always viewed as a useful exercise.
Well, I just wanted to clarify that, Chair, just so to put it in framework. I have some question about, and if I could continue with you, Mr. Tatian, I'm not, do I have it? Excuse me for my pronunciation. You mentioned in your remarks earlier, I think that there are a range of Indigenous communities whose lawmaking powers may differ. Those, for example, that have self-government agreements. One might even add those whose rights have never been so-called extinguished, their territory never ceded, to those who are under the auspices of the Indian Act and have some bylaw power over intoxicants. So a two-part question, and I'm interested in your answers. One, is it realistic to think that given the diversity of communities with diverse legislative powers, that the deliverable as called for in the amendments, it can actually be achieved within a one-year period? Or might it take longer to sort out whose lawmaking powers might apply, to say nothing of working through whether the criminal code in all of its aspects would continue to apply as a law of general application? That's the first part. And the second part is, with regard to the bylaw power under the Indian Act that gives communities the ability to legislate with regard to intoxicants, am I correct in understanding that at least to date, intoxicants has been narrowly interpreted to include alcohol, but not necessarily drugs like cannabis? And could you just comment on that and whether you think there is an opening on the government's part to treat the term intoxicants more broadly than it has hitherto been treated? Thank you.
Well, maybe I'll just start with the first question. I do want to say that it's not that there's a lack of clarity about the nature of the proposed legislation. It is legislation of general application. It will apply if it's given royal assent. You know, upon royal assent, it will apply to all Canadians, including the Indigenous peoples. There is no lack of clarity in that respect. There will be, I imagine, ongoing work with Indigenous governments and organizations on how to, you know, as we've heard, how to deal with some of the issues related to legalization within their communities. But there is no lack of clarity about the nature of the legislation itself. In terms of the second question about the intoxicants provision of the Indian Act, the Indian Act refers to intoxicants as, and it's actually partly the nature of the French definition as well, does suggest that it deals with alcoholic beverages. There, on a review of several First Nation bylaws, you can see that some First Nations do also, communities that have established themselves as dry communities, as the phrase is used, have used their bylaw-making powers, and typically they would refer to a number of bylaw-making powers, not just the one that deals with intoxicants, but also health and safety and other provisions under the Indian Act, as the basis for dry community bylaws that touch on both alcoholic beverages and in some cases drugs identified under the Drugs and Controlled Substances Act. The validity of those bylaws is always a question that the courts would have to determine. And I guess I would just leave it at that. But, ultimately a First Nation government goes through a process of determining what they believe their authorities are under the Indian Act or under other sources if they're a self-governing First Nation. The federal government is not involved in reviewing First Nation bylaws, as used to be the case several years ago.
Okay.
Hopefully that answers.
Senator Tennis.
A couple of things. I guess just some words on consultation and what we heard. And notwithstanding, Mr. Costin, what you said, we saw the list of who was consulted and what activity was done prior to the cake being baked, right? And it was precious little. There was a roundtable in Vancouver with Madame McClellan's task force. There was a phone call on multiple issues to the head of ITK, and this was one of the items on the phone call, according to the head of ITK himself. But it was listed as pre-drafting consultation. Nothing else. And then there are 90 different points of engagement that have happened since this bill, which to date is perfect, has no need for change. That's what we have. I asked the minister at our committee, is there one word in this bill that has anything to do or has been influenced by the consultation that took place? And got no answer. So we need to do better. Words and deeds with this government are not matching up. And you know what? It's hard work, and I have a lot of sympathy for all of you because I know and have heard privately it's difficult to engage if the other side isn't ready to engage. That's part of the challenge, and I wish you well with getting better at this. I want to just focus on the licensing. And Mr. Costin, how many of the existing licensees around cannabis have multiple facilities? Most of them would have multiple facilities, or do you have a bunch of one-offs?
I'll give you a kind of a general answer.
Yeah, that's
if you
all I'm
need
looking
precision,
for.
I'd have to get back to you. So there's about 104 licenses issued across the country currently. There are a handful of what I would describe as the sort of the really big players. And in those instances, those bigger companies have multiple licenses, multiple sites.
So if you said, would it be tough for you to say to those guys who will dominate the recreational market? They've got the money, they've got $37 billion of market capitalization behind them. Would it be tough for you to say, boys, you're not getting a fifth license unless it's on Indigenous territory? Would that be so tough to do?
Would it be tough for us to do? I mean, there are abilities, there are provisions in the Act that allow for prioritization, like decisions around, would allow the minister to have discretion to establish some type of criteria and and then allocate licenses based on that. And so in that kind of construct that you've just described, I would think, just look at my colleagues here, that I think the authorities that are proposed would accommodate that type of situation. Is that fair to say, guys?
Yeah, I mean, what I would say is that there are provisions in the bill to prioritize the consideration of applications, but the system for licensing itself is based on public health and safety considerations. And so the criteria, the decision-making for whether or not an applicant actually receives a license or not is based on the purposes of the Act, and to the extent that it helps achieve those fundamental purposes, which are really tied to public health and public safety.
I would disagree. I would say this is also an economic development of historic proportions, an economic development opportunity of historic proportions. And First Nations and Inuit, Aboriginal people across the country need an opportunity to participate. And if we pair that with consultations or the lack thereof, which can lead to a lack of preparation, it seems to me to be fair that we might give a little help to the economic development activities that Madame Murphy is in charge of. And I'd like to turn to her now that we've heard that this is not impossible, infinite licenses can't be done, etc. We could actually, if we turned our minds to this, I think we'd have faith that you could figure that out. So would you, Madame Murphy, say that you are somehow concerned about the idea of an advantage, if you will, for Indigenous employment, Indigenous economic development around this notion of, 1 in 5 facilities should be located on Indigenous lands?
So, I mean, I'm not going to, certainly we have changed our authorities to be able to accommodate Indigenous communities who want to come forward with proposals in and around establishing production or distribution of cannabis. It's certainly in entertaining those proposals from an economic development point of view, where they might want to do a feasibility study, they might want to leg up to help leverage money from the private sector or from a partner. We do have the parameters that they will have to have been licensed by the system, and in the case of a community, we would want to make sure there was community consent, so that the community is knowledgeable and has agreed to that kind of economic endeavor occurring within their community. But once that has happened, we're quite happy to work with communities and with businesses who want to get into the business, and in fact we already are discussing with a multiple number who are very interested. Many of them have private sector partners. They're not necessarily going to locate on reserve. They may be doing it in an off-reserve context, but they are eligible for funding within our program parameters. We've received, when I was here last time, we said that there were a number of communities considering this. We've actually now received 3 proposals which we're looking at and working with communities on. And we are also working with our regional development agency partners to make sure that with the money that we have and where proposals make sense and they've gone through the appropriate licensing provisions, that we work to make those successful.
Thank you very much.
Okay,
Thank you, Chair.
Next, I have 4 more senators on the list. We've got 15 minutes, so if we could tighten it up a little bit, please, both the questions and the answers, we'll get through this. Senator Manning.
And thanks again to our witnesses. I just want to follow up on the consultation process, and Minister Pettipas-Taylor and Bill Blair have both said that the government relied heavily on the feedback obtained by the task force. However, according to a report of consultation table with the APA committee, which Senator Tan has just touched on, the majority of consultations, or rather engagement sessions, as the government has repeatedly called them, took place after the bill was introduced. Furthermore, the vast majority of consultations occurred after the bill was introduced, occurred after the bill reached the Senate. Can someone tell us today, point to one specific clause in the bill that incorporates the feedback concerns of the Indigenous people?
I mean, it's a difficult with the I mean, you've heard the numbers, right? 30,000 submissions to the task force and these sorts of things.
Yeah, and what I'm trying to get at the consultation process is, the ministers and the parliamentary secretary said that the feedback obtained by the task force was what government relied heavily on.
That's right.
And the question is plain and simple: can you point to one specific clause in the bill that incorporates the feedback of concerns of Indigenous people in Canada? Yes or no?
Well, what I was trying to say was, so take for instance, and I take the point that the senator made earlier around that this has been a kind of the consultations have kind of grown, interest has grown, and many invitations were sent out during the task force consultations, and not all of them were responded to. So to answer your question, Senator, so take for instance the conversation around minimum age. And the determination that the age should be 18. Arriving at that recommendation, the task force sat in rooms not unlike these and heard from many different perspectives, including from the Indigenous perspective. So to the extent, and as they worked through all of the different issues, the voices around the table, including the Indigenous voices around the table, would have been considered as a part of the process for determining that advice. But to be able to isolate one particular element and ascribe it to any one individual person or individual group would be very difficult, because the nature of the consultation was to hear from a diversity of voices, balance out the advice that's being provided, and provide, in many cases, what's the word I'm looking for? A middle ground. That's not the word I'm looking for, but to take the balance of the advice provided. That's why it's very difficult to point at one group, one organization, one person and say, this is what you contributed to this bill, because it really was a lot of voices.
Just to give my colleagues some time, I'm going to forgo my next question, Mr. Chair.
Oh, thank you. Senator Ahmed.
Thank you, Chair. I have a few questions, and I'm going to try and get them put on the table as tightly as I can. You did speak, Mr. Costans, about the impact of delay of recommendation number 1, which speaks to delaying the legislation. Could you speak perhaps specifically, though, on the impact of delay on Indigenous peoples in Canada, given their current overrepresentation in the criminalization in our system, and their overrepresentation in prisons?
I'll do my best. It's a big question. Perhaps what I'll do is I'll pick up on comments that Valerie was making earlier, questions that were being asked by the Honourable Senator previously. So the data that we have right now around use of cannabis would suggest that about 36% of First Nations young people use cannabis. 32% of First Nations adult use cannabis. So the opening premise needs to be that cannabis is widely available, widely used. So the harms associated with using that cannabis exist today. They're not born of the change in law. The challenges associated with lack of services, whether they are mental health services, drug treatment services, for the 36% and the 32% that I just described, they exist today. And it is and I don't want to put words in Valerie's mouth, certainly, but it is that's an urgent problem, and Valerie described a number of things that her program is doing to respond to that. So to the extent that the committee is considering what the impact of delay would be, that's the backdrop, I think, for assessing what the impact would be, and in the interest of keeping it tight, maybe I'll stop there.
Thank you. Second question. There's such a distance between what the Aboriginal Affairs Committee has heard about lack of consultations and what you're saying. So I'm trying to understand and come to my question. Do you have any parameters, criteria, framework that help you define what an adequate consultation would be? Or is it just a checklist?
So what we do, and again, we did this with the task force. So what we do is we set out a consultation strategy, right? And in many ways, that, in the case of the task force, was derived from the mandate they were given, right? So if you look at the terms of reference that the government provided to the task force, it isolated and prioritized certain groups that the government wanted the task force to go out and talk to. And so those terms of reference are, I think, actually even appended to the report. And, provinces and territories, indigenous communities, experts in a variety of fields, and so on and so forth. And from that, we develop a strategy that says, okay, so what tools are we going to use to hear from these people? Who are the influencers? Who are the major organizations? Of course, the task force had they had 4.5 months to do their work in. So how do we get the biggest bang for the buck, so to speak? How do we design a consultation strategy that will hear from as many different people representing those target groups in as many different ways as possible? As a program, and again, I leave it to others to judge the success or failure of the efforts, but that's the strategy that goes in to developing what would an adequate consultation strategy look like. And then we replicate very much the same thing as we move through different stages. And as another very quick example, we've mentioned a few times that we did some consultations on a proposed regulatory approach. We did the same thing. Identify who are the target audiences, and Indigenous groups were very much front and center. They're one of others, though. What are the different strategies that we will deploy to get to them? And so that's, I think, the best answer that I can give you around how we approach the thought of adequate consultation.
Okay, thank you. That was.
Let me just pick up on that, because I've heard that to the Indigenous community, consultation has a broader meaning than what we might generally consider it to be in the general community, let's say. It's not just a question of going in and saying, well, here's our idea, what do you think? It's a question of sitting down and actually something more formal being conducted, almost, I suppose, a negotiation. Maybe it is a negotiation in effect. Is that your understanding?
I don't know that I have a lot to say in response to that. The legal implications of the word consultation, I don't know that I have a lot of expertise there. I don't know, Stefan, if there's anything you want to say about that, or others.
Well, I don't know that there's much to add from that perspective, in the sense that I think what we're talking about is, adequacy of consultation in the context of a policy and legislative development process. And I think Eric has tried to, characterize some of the considerations that go into that.
Okay, thank you. Senator Deakin.
Much. My question, I think I'm going to pass, because I feel like Senator Petitclerc and Senator Ten have really covered that area. But without trying to sort of flog and talk about the consultation over and over again, I do believe it's something that has been a critical piece of the recommendations from the APPA, and great diversity in perhaps understanding what that is and what it means. I just want to take a moment through this C45 process. What's been continued to be very clear for me is that great diversity in the understanding of readiness and consultation. And the readiness piece is, and just really pausing and saying, I hear the term, we are ready. Are we ready? What does readiness look like, feel like? What should it be? Do we have embedded in that readiness, in that process, how we're going to monitor and measure what we're going to measure to see how we're doing, and being agile and adjusting as this process moves forward? And I feel like that's come out clearly in a number of different ways, that readiness piece and the consultation. And the consultation is really part of what we call an engagement continuum. So when we're going into the communities and we're talking to our colleagues, and today we're talking about our Aboriginal peoples and their recommendations, there are 3 areas in that continuum: informing, consulting, and collaborating. And as we go into the room, into the house, into the meetings, was it clear, or what I would suggest we think about it being clear, what are we informing about today? What is it you need to know? What is the education piece with some very clear principles? What are we going to be consulting with you about? reciprocally? And what is it we're going to collaborate and work on together in a meaningful period of time? We're not going to have all that in place on July 1st. But in building the conditions that look at that engagement continuum, of which consultation is a key part, I think is going to help us get to where we need to go in this area of the work. I'll pass on questions, but just want to tie that together.
Thank you. Good comment. Thank you. Senator Poirier will be the last.
Thank you, Chair. Thank you all for being here again. My question today is, we've heard over many times from Aboriginal leaders, police force, municipal leaders, mental health groups, and I could go on, many, many different groups, about the concerns they have of enforcing the 4 plants at home, whether they will be, whether it will be impossible to monitor, and should actually even that aspect of the law be scrapped. And I know we talked a little bit earlier we talked about the plant itself and the cultivation of the plant indoors and outdoors, and we mentioned about outdoors that it had to be not in the budding or the flowering stage, if I remember right. I also am aware, being from New Brunswick, that New Brunswick has put provision in their provincial law that the outdoor at the house home plants can be done outdoors, but they're saying that it has to be within a closed or fenced-in area at the same time. I'm also aware that there is quite a few First Nation communities in New Brunswick also, which means this law will also be applied or available to them to do the same thing. And so I'm just kind of wondering, are we prepared, are the Indigenous people prepared to enforce this service, to be able to monitor this service about the home cultivation and specifically with the outdoor parts of it? The police could maybe answer?
Yes, so having served half my career in New Brunswick, I'm very familiar with the First Nation communities in New Brunswick. I'm not sure, I think you framed it, will the Indigenous people as opposed to the police,
The Indigenous police force, will they be able to enforce in the First Nations as much as will the police force and the municipalities and everything be able to handle? And everybody seems to be concerned about it in New Brunswick. I'm hearing an awful lot about it.
As you know, in New Brunswick and with the other provinces, the RCMP are contracted throughout, with the exception of Ontario and Quebec, to provide policing services, including the North. As I had earlier stated with respect to the earlier committee, when it comes to home cultivation, of course, my role in law enforcement is to enforce the law as when it passes. As far as being able to enforce that, again, I made comments earlier, when I look at that situation, I look at public safety in general, and I'll look at other things such as access to youth, say within the home. I would look at potential for fire, anything that I had previously mentioned would all come into how I would address the enforcement of home cultivation. So let me be clear, though, the RCMP will be ready to enforce the legal cannabis home cultivation or not. We will be ready to do that. And we are providing support across the country to the law enforcement community with awareness, with training, so that across Canada, one would expect that law enforcement across the country, whether it be RCMP or not, would be able to enforce the law on an Indigenous community or off.
Do you feel that we will have the manpower in the number of police officers needed to enforce this law? Because I'm hearing from the municipalities also that they're fearing that they may not have the finances to be able to have the number of RCMP or police force that they need in order to even look at monitoring this law.
what I can say to that is there are mechanisms. We contract with through Department of Public Safety with provinces, and there are mechanisms in which to increase, if that is the need of the particular municipality or province. There are mechanisms to increase. The RCMP, we do through our annual performance planning meet with the communities, Indigenous or not, and form performance planning for that year, and those will be in consultation with the communities to determine their priorities. Then we would distribute the enforcement capacity, people power to be able to then react as necessary.
Okay, thank you. If they can afford financially the extra costs. Thank you.
Thank you very much. Well, that brings to an end this panel now. And thank you very much for all of the input on this particular report. The next item on the agenda is a break. And just like the number of plants, I'll give you a choice, 10, 5, or 0. 5 minutes? 5 minutes it is. We'll resume in 5 minutes.